the fourth exception to liability in torts is necessity. Necessity means that if the circumstances are demanding for an immediate action, then it is not necessary that the laws should be strictly followed. So, necessity justifies an act which would otherwise be wrongful. So, an act causing damage, if done under necessity to prevent a greater evil, it is not actionable even though harm was caused. Basis of this defense is based on either charity or maintenance of public good and self-protection, and it is limited to cases of urgent situation of imminent peril. So, this is the very meaning of necessity as defined under law of tort. And there are certain examples which would clarify exactly necessity means what. The examples are pulling down a house on fire to prevent spread of fire, or throwing goods overboard to lighten a boat in a storm, or demolishing a building which has become dangerous and may fall on a public highway are of the defenses of necessity, and these are some of the examples of clarifying what exactly necessary or necessity means under law of tort. And regarding that also, we would discuss certain important leading cases, and one of them is Burma Oil Company Limited versus Lord Advocate in 1965, which was decided by the Civil Court of Appeal. Here, the Crown was held not liable as the War Damages Act 1965 under Section 2 subsection 1 provided that the Crown was not liable in respect of damages or destruction of property caused by acts lawfully done in the outbreak of a war in which the sovereign was or is engaged. So we'll discuss another important leading case, and that is Southport Corporation versus Esso Petroleum Company Limited, and it was a case of 1945 decided by the King's Bench, and where it was held that the operations carried out by the defendant Petroleum Company, although created the dangers on the very periphery, but as it was a work of economic development and that would lead to public welfare, so there was no fault of the defendant. And besides these two leading cases, another important leading cases, and that is Greyvensteyn versus Hatting in 1911, and it was decided by the Court of Appeal, where it was the very act performed by the defendant, that was driving away from his land a swarm of locusts, which in consequences entered the plaintiff's land and damaged his crops. And here the defendant was not held liable, as because driving away of the locust from his land, it is a kind of necessity, although his intention was not to damage the crops of the plaintiff. So, besides that, there are certain limitations, and those limitations which could be derived from the following cases. So, when we discuss regarding limitations, the first case was I.Whalley versus L&Y Railway Company of 1884, decided by the Queen's Bench. On for avoiding harm to one's land, one could not divert a flood to his neighbor's property, and if it would be done, then it would not be held as necessity. So, diverting flood to one's neighbor's property and causing damage is not falling under necessity. So, there the defendant would be held liable. And in the same way, in another important leading Indian case, and that was Shankar versus Laxman in 1938, the Bombay High Court was held that the defendants could have put an embankment to prevent entering into the land of his neighbors. So, as per the decision of the Bombay High Court, to avoid causing any damage or harm to the neighbor's property, the defendant could have built an embankment to prevent entering of the flood waters into the plaintiff's land. So, under these two leading cases, we found the very limitations on the clause of necessity. So, here necessity could not be held as an exception to liability in tort. So, in our next video, we'll discuss the fifth exception, and that is private defense.